Supports that. I call the honourable member, the Honourable Marianne Street.
Thank you very much, Mr. Speaker. It seems to me to be one of the great unanswered existential questions as to why the Plumbers, Gasfitters, Drain Layers Board has had such a fraught and wretched history. Because every time I've ever employed a plumber, a gasfitter or a drain layer, they've turned out to be perfectly jolly men and have got on with the job. And so to have this level of controversy bedevil this board over many years is something that some of us in this House find fairly inexplicable. Mr. Speaker, I do want to make a reference to the fact that this goes back to 2006 legislation, as the previous Speaker, who's just resumed his seat, said. That's absolutely true. And it was a complex piece of legislation at the time. I remember it well, as the member Chris Ockenvold referred to earlier. And it had to be divided into two parts in order to try to get it right. But the interesting thing, perhaps, for the member who's just resumed his seat, is that the fault with this bill didn't become apparent either to Labor or National until 2010. So this is not something that the National Party can say, oh, we spotted this years ago and you guys just didn't do anything about it. It didn't come to light. They were not aware of it. We were not aware that the provision would be misused in this way until 2010, when an additional levy was applied by the Plumbers, Gasfitters and Drain Layers Board in order, as I understand it, to try to get cowboys out of the industry. And that is the purpose of the bill. But the purpose of the board was to gather revenue in order to prosecute and investigate any breaches of the acts that covered their activities. But the Act only applied to registered people. So perhaps another lesson in this for the public is, for goodness sake, make sure you get a registered plumber, gasfitter or drain layer, and don't go for one of the cowboys who says, oh, I've got a spare piece of that in the back of my van. It'll just do the trick. So the lesson to any householder at home is to make sure that you get a registered person. However, that's not the subject of the bill, although it is the purpose. It is the purpose of the bill, as it says quite clearly, to get rid of uncertified practitioners in the industry. And as I understand it, this is what the board was attempting to do with this levy, which has turned out to be illegal. And that discovery came to the attention, came through the application of the Regulations Review Committee. At the time that the original legislation was going through the House, I was also on the Regs Review Committee, 2005 and 6 and most of 7. And I remember this coming there, and I remember complaints and the board appearing in front of the Regulations Review Committee as well. But this has come to light because of the scrutiny of the Regulations Review Committee, which goes to underscore just how important that committee is, because it scrutinises things that otherwise do not get any parliamentary scrutiny. And that is its purpose, and it performs a hugely important function in that respect. Everything we vote on comes to this House for a vote. The things we don't vote on, that are exercised by regulation, promulgated by ministers and orders in council, do not get scrutinised by this House. And so we need to respect the view of the Regulations Review Committee, and not only respect their views, but respect their function. I need to say, Mr. Chair, that I dislike retrospective legislation to my core. and this is the second time in 2 weeks I've got up to make a speech about retrospective legislation. The last time was on the Tasman District Council, validation of rates that had been misapplied. And I hate it. But we're in the situation where this House has very few alternatives. Either we bankrupt the Plumbers, Gasfitters and Drain Layers Board, which is in nobody's interests, not the industry's interests, not the members' interests, not ordinary people who require the services of these tradespeople. It's not in their interests either. And so I have to bite the bullet on this one. I don't like retrospective validating legislation. It's correcting an error. Somebody's done something illegal and Parliament has to fix it, otherwise people will suffer as a result. So for that reason, Labour is supporting this bill, but not without reservation. There's one other item that I want to bring to the House's attention, and I bring it to the attention in this first speech, Mr. Speaker, because there is such a short time frame for the Select Committee to hear this, and the previous Speaker from the Green Party referred to that substantially. But there are some things in the content of the bill itself, Mr. Speaker, that, that require some reconciliation, and I hope that the Minister's officials will, during the week of that the bill is in front of the Select Committee, provide the Select Committee with some way of resolving Section 4, Clause 2(1), which provides the new process by which the Board may legitimately apply a levy for disciplinary and prosecution purposes, with the new Section 171B, which comes under Clause 5 in Part 2 of the bill, which refers to any amendment on the date or after the date that this bill comes into force, will render the previous validation ineffective. So it will, the validation that we're trying to pass here will cease to apply if the Board moves to make an amendment to the fee on or after this bill has come into effect and become an act. And I think there is a contradiction between those two things. I think that if the Section 142 power that was used by the Board to prescribe the original offence fee was dubious enough to require validation by this bill, then surely it cannot be a lawful basis for the Board to use in amending the fee. And if the bill is enacted, an argument can be made that the Section 142 power, insofar as it was applied in prescribing the offence fee, is implicitly repealed by the new empowering provision inserted into Clause 5 of the bill. I do think that the policy intent behind the... Sorry, that was meant to be Clause 4 for Hansard's purposes. I corrected it to 5, but it should be Clause 4. The policy intent behind new 171B is to tell the Board that if it amends the offence, then it won't have the protection of the validation provided for in the bill. I think this sends confusing signals. I know the Minister's office and the Minister is aware of my concerns in this regard, and I would hope that officials would be able to mend what I see as a difficult set of competing signals before the bill is passed into law. Thank you, Mr. Speaker.